and gentlemen, thank you so much for coming tonight to the People's Law School. It is an honor and privilege for me to be here and present to you on behalf of the Alabama Trial Lawyers, also known as the Association for Justice, the Alabama Association for Justice. The best lawyers in America, and I'm going to tell you, the next one is, by golly, if she isn't there, she's going to be, because Sarah Taggart, Huntsville's own Sarah Leopold Taggart, is knows more about the topic she's going to talk about than just anybody I know. She's written a book on it. You can get it if you call her office. But she graduated Phi Beta Kappa and magna cum laude from the University of the South in Swanee. She went on full scholarship to Washington University there in St. Louis, Missouri, and then came home and decided to set up her own law firm, and it's called Sarah Taggart, PC. She specializes in representing landlords. She represents landlords in all 67 counties of Alabama, and she is who I perceive as the expert in the field. She knows it all. She's lectured all over the state and several other places. And as I said, her book is called The Alabama Landlord. And meanwhile, back at the ranch, she also has a 2.5-year-old boy named Colin. So I will tell you, it is my privilege, it is my honor to present to you Miss Sarah Taggart. Thank you.
All right, well, thank you all for having me at the People's Law School tonight. I'm very excited to be back to talk about what I think is one of the most interesting fields of law. Scanning your curricula, I realized that I'm probably the only real estate practitioner that you have this term, so I thought I would take a minute to sort of talk about real estate law in general before focusing on my specific field of law, which again is landlord tenant law. Okay. Real estate law, what is property law? Real estate law concerns itself with the ownership interest in real property being considered mainly dirt or land, as opposed to personal property, which are possessions. So property law governs the ownership and tenancy of real property. That's loosely defined as rights over things as opposed to rights over people or contractual rights. And practitioners of property law do a lot of stuff, from the sale of property and real estate to easements, restrictive covenants, or in my case, tenancies. So, tenancies. The best definition I ever got of real estate law, or of property rights, was describing man's relationship to things like carrying a bundle of sticks, sort of like firewood. This is again man's relationship to the dirt. Each one of those sticks that they hold is a right. You know, the right to sell it, the right to paint it purple, the right to set it on fire. Every right that man has with relationship to land is a stick. And if you have all the sticks, you own the property outright in what we call fee simple. That means that you have all of the rights with regards to that piece of real property, with regards to that piece of dirt. And then you start giving your sticks out. You can give the stick out of being able to live there. That's considered a tenancy. You could give the stick out of being able to sell it, the stick out of being able, again, to paint it purple. And that's sort of where we are with man's relationship to real property. And everyone's confused. So we will start again with what is real property law. Real property law concerns man's relationship with the dirt. That's really what it is. And tenancies, residential and commercial tenancies, are defined as having a certain number of sticks, a certain number of rights with regards to this land for a fixed duration of time. That's what a tenancy is. You're letting somebody have a certain number of rights with regards to your land for a fixed duration of time. That's a leasehold or a tenancy. Leaseholds are generally set by contracts, which are called leases. Leases can be, again, for any amount of time. They can be residential or commercial. Whether something is a residential or commercial tenancy is defined by what the principal purpose of business is going to be there. If you have a residential tenancy, somebody's living there. If you have a commercial tenancy, somebody's doing business there. Lots of confused faces. I do allow questions. It's probably what differs from the other lecturers that you've had. I prefer an interactive environment. I also prefer pacing a room. So this is very unusual for me to be trapped at a podium. At least I'm not doing this time. Okay. Residential tenancies are defined as fixed duration periods where somebody has the right to live there. They have the right to what we call exclusive possession. They have the right to possession superior to all others. They don't have the right to sell it. They don't have the right to add a wing. They don't have a right to put down hardwood flooring. They just have the right to exclusive possession. Commercial tenancy is same basic principle. You don't own the building, but you own the ability to do business out of the building, governed by a contract, that contract being the lease. Any questions? Okay. What? Nobody wants to be on TV except me, yes.
Well, oftentimes people will rent a space for business and then modify the space to meet their business needs.
Mm-hmm. The difference between residential and commercial tenancies is interesting. Commercial tenancies, you can do pretty much anything. You know, you can negotiate a contract between generally two business people, and you can do what we call a build-out, where in a commercial tenancy, the commercial tenant may demand that you put in extra shelving, that you adapt it for the business, that you add certain fixtures. Commercial tenancies and negotiating commercial leases, it's very much a give and take. It's what both business people can agree on and negotiate. And there's very little guidance in state law limiting or restricting a commercial tenancy. You can do pretty much anything. You know, if you want to make it so that the tenant is responsible for all the maintenance and for all the repairs, you can do that in a commercial lease. If you want to make it so that the landlord is responsible for adding in or building out the kitchen or adding the industrial strength ovens or, you know, ventilating it for a nail salon, you can do that in a commercial tenancy. There's no real restrictions. It's what people can negotiate for. It's very much capitalism and the bargain and the market that determines it. Residential tenancies are a little bit different. At common law, you know, landlord tenant law is again an element of real property law. Real property law has not changed since William the Conqueror in 1066. That is when we got our basic feudal system at common law with regards to man's relationship to dirt. And all of the terms in real property law are Old English. And, you know, terms like seisedom and again, in rem jurisdiction, it's all Latin, it's all based, it's all Norman. So residential leases at common law, there were no restrictions on what landlords and tenants could do. Generally, a tenant took the property, which was usually farmland, as they found it. There was no obligation for a landlord to maintain it. There was no obligation for a landlord to make sure that it was habitable. The tenant was on their own. And we had that in real property law up until about the 1960s. And that's when there was a trend nationwide in almost all fields of law to move away from sort of the buyer beware, you know, to a more consumer protectionist kind of environment. So that's when, especially in landlord-tenant law, we see a sea change in the way that judges handle law. And that's when we see the idea of a warranty of habitability, city ordinances, city codes, restrictions on the agreements that residential landlords and tenants can strike, and an idea that in residential tenancies, the landlords and the tenants don't have equal bargaining power. So that all started to happen in the 1960s, and it never happened in commercial law. So in commercial law, you can basically do whatever you want. It's whatever the contract says. Residential law, there are certain parameters, and we'll get to them, of what you cannot contract around. Questions? Yes?
I was on a piece of property, and I've got all these sticks that you're talking about, and it comes along an endangered species or something. Somebody's taken away a stick from me. What do you have to say about that?
Well, you see, you've got to understand that the sovereign owns all the sticks. It's all just an illusion that we have our sticks. The sticks are all really owned by the government. But that, again, is a deeper political and philosophical question beyond the scope of this 1-hour lecture on property law. The thing I love about property law, in property law, I wish that you had a practitioner that could sort of articulate it a little bit better than me, but property law says so much about our society and our relationship with sort of the sovereign, with our relationship with each other. Because but for a government respect of property law, if you didn't know when you went to work that when you came back your house was still your house, we would all be sitting on our front porch with our dog and our shotgun. So property law is what allows society to be productive. It's what allows us to go out into the world, do our jobs, live our lives, and know that when we come home, our home is sort of our sanctuary, and we are, you know, in criminal law, there's a warrantless searches, you know, every man's shack, no matter how flimsy, is his castle and cannot be entered by a sovereign. So that's sort of what I love about property law. It tells us a lot about where we sort of allocate our rights and things like that. So yes, if there's a spotted owl on your property, you've lost a stick. I'm sorry. The stick belongs to the spotted owl. Okay, so residential landlord tenant. We've taken it big. You own the property outright, all the sticks in rem. This is your property. You can do what you want to it. We're going to say that for some strange reason you've decided that you want to have it be income producing and you want it to be a residential tenancy. That means you basically own a single family residential house that you want to rent out, or a townhome or an apartment. You've decided you want to be a landlord of a residential tenancy. And I'm very thankful that there are those out there that do it, because that's what keeps me in practice. But if you make the choice to be a residential landlord, you are in for a roller coaster ride, and there's no other way to describe it. Because people do strange things in their houses, and they do even stranger things in houses that don't belong to them. As I can say, over the last 8 or 9 years, having done the landlord tenant law. So, in commercial leases, as we talked about, you can do whatever you want. Sky's the limit. If you can get a commercial tenant to agree to it, more power to you. And I have seen some commercial leases that have what we call acceleration clauses that say the minute you default, the whole balance of the contract comes due. I've had commercial leases that have said that the tenant has to pay for everything, including the property taxes on the property, including all of the maintenance, putting in a new HVAC. Commercial is whatever the parties can bargain for. Now, I've seen some commercial leases where the landlord is doing pretty much everything except running the business. So it's a bit of a what kind of property you have, how attractive it is, where it is located with regards to commercial tenancies. And I do quite a bit of commercial evictions, but that's not what I wanted to talk about today, because I figured in the room I was far more inclined to get a residential landlord or a residential tenant. So, if you have a residential tenancy in the state of Alabama, it is governed by what we call the Uniform Residential Landlord and Tenant Act. In your handout, there's a link that will take you to the Uniform Residential Landlord Tenant Act. This is not the only piece of law that governs a residential landlord in the state of Alabama. We still have federal fair housing law that we're subject to, and local and city codes and ordinances with regards to habitability. Those are still something that an Alabama landlord has to worry about. But as far as the meat of the law that is going to govern an Alabama landlord, it is in the Uniform Residential Landlord and Tenant Act, found in the Code of Alabama, Title 35, Section 9A. Don't go to Section 9, it's still in there. It was superseded by Section 9A. Why they didn't take 9 out is beyond me, but I end up with landlords that will read 9, think they're doing great, and then find out that the entire field, that entire statute is obsolete. 35, 9A. Now, the passage of this is interesting. Until 2006, landlord-tenant law in the state of Alabama was kind of patchwork. Up here, we did something called a Sanderson Act eviction, which was 2 10-day notices and counter affidavits, and it was before my time, and I just sort of hear kind of like it was the best thing that ever happened or the worst thing that ever happened, depending on my clients' past experiences with it. But down in Coleman, past Coleman, they did the 35 9A evictions, and then they did something completely different down in Mobile. And different counties were starting to enact different sorts of tenant statutes. And so the legislature recognized that it was going to be a problem that we did not have a uniform sort of tenant code, a uniform landlord-tenant act. And so there's quite a bit of wrangling and wrestling between the various interested parties on what the Landlord Tenant Act should be. A uniform act is, again, a trend out of the 1960s where they wanted to get more uniformity amongst the states in different types of law. It's model acts. If you have a person who talks to you about family law, there's a model act for child custody. If you have a person who talks to you about criminal law, there's a model criminal code. There's a model Landlord Tenant Act put together by a bunch of really smart people out of D.C. That's where I'm assuming it comes from. The American Bar Association gets together and they put together these model acts based on what they feel should be sort of an allocation of rights between various competing parties. And then states enact model acts in whole or in part. They make a decision, they pick and choose, they decide what parts of the act they like, what parts of the act they don't, and then they pass sort of a uniform code for their particular state. And that's what in 2007 happened in the state of Alabama. The legislature passed a significant portion of the Model Act, and it became the Uniform Residential Landlord and Tenant Act. If you print it out, it's about 40 pages long. If you print out the commentary with it, it's about 60 pages long. It's designed to be user-friendly. It does not mean it is user-friendly. It means it's designed to be user-friendly. It's been amended twice since passage, in 2009 and in 2011. Each time the amendments have sought to kind of kick the tires, clarify what they meant the first time around, and sort of swing the pendulum back from being what most of my clients view as incredibly pro-tenant to being what legal services now views as incredibly pro-landlord. So we're trying to figure it out and figure out where we want to be. But it's been amended twice since its passage. Again, about 40 pages if you print it out, 60 if you print out the commentary. If you own any rental property, it is certainly worth watching or reading. I always tell people to get your vice of choice, be it a box of donuts or a bottle of wine, and just plow through it, because you need to know the law that governs what you're doing. And it is designed to be, as I said, user-friendly. There are some terms of art in there, legal terms of art, but for the most part, it's pretty straightforward. It's got a definition section where it defines what a landlord is, what a tenant is. It has a section on tenant obligations where it says what tenants have to do. It has a section on landlord obligations, says what landlords have to do. And then a section on defaults that governs what happens when landlords don't do what they're supposed to do and tenants don't do what they're supposed to do. And that's it. I'm actually incredibly blessed in my practice to have a field of law that is as narrow and sort of in one place as my field of law is. Of course, lawyers can't make it that easy. We still have cases that interpret the various provisions of our statute, but for the most part, it's very self-contained. Remember when I was talking about sticks? That had a deeper purpose. The Landlord Tenant Act governs landlord-tenant relationships. It does not govern lease-to-purchase agreements. Contracts for deed, installment sale contracts, those are not considered landlord-tenant relationships. What a lease-to-purchase agreement is, it generally recites that a tenant's paying a chunk of money, and then either every payment they make on time, they get a credit to a certain amount at close, or if they make 7 on-time payments, then they can be structured any way they want. But the minute that you have a tenant with an equitable claim, you no longer have a landlord-tenant relationship. It's not governed by the Landlord Tenant Act, and you can't evict. If I could tattoo it on my forehead, I would. This is one of the many things I would tattoo on my forehead. The first one would be lease-to-purchase agreements are not governed by the Alabama Landlord Tenant Act. If you do a lease-to-purchase agreement, there's a way to get your tenant out, but it is not the quick and easy eviction. So don't do a lease-to-purchase agreement unless you're comfortable with your property being tied up in circuit court on an ejectment action, which some of you might understand is about 5 times longer and about 20 times more expensive than an eviction. So don't do a lease-to-purchase agreement unless there's a lot of money in it for you.
So how do you protect yourself?
In lease-to-purchase agreements, you don't do them. And I think I am single-handedly responsible throughout the state for the death of the lease-to-purchase agreement. Most realtors won't even touch them now. I go into a new county, I give my talk on landlord-tenant law, and they all stop doing lease-to-purchase agreements. let me do what a tenant is, let me get all the way through that, and then I'll have a big question and answer time at the end, and if you want to do that one, we'll talk about it. But specifically excluded from the protections of the Landlord Tenant Act, tenancy pursuant to a sale, lease purchase agreement, tenancy at educational institution, medical institution, jail, or place of worship. I do not have to evict nuns, thank you. I do not have to evict college students. I do not have to evict inmates. So happy. Also, specifically excluded from the protections of the Landlord Tenant Act would be hotels. Although that is not as clear as it sounds. Sometimes you can have hotels that straddle the fence. The extended stay hotels, where they're the person's only place of residence. On occasion, I do actually have to evict from hotels. But that is sort of what is not covered by the landlord-tenant law. That is what is not a landlord. Also, familial relationships or romantic relationships that have broken down. If there's never been a measure of rent paid between the parties, I can't evict. Everybody's looking at me, but it happens about once a month. Someone will come into my office and want to evict their adult child or their boyfriend that's not moving. That is not what the Landlord-Tenant Act is designed to do. So, that is what is not covered by the Landlord-Tenant Act. What is covered by the Landlord-Tenant Act, again, is what we talked about, residential situations where you have rented it out either by oral lease or written lease for a fixed period of time. And you can have an oral lease. There's no requirement that your lease be in writing. The only things you have to have is a measure of rent that's been agreed upon by the parties and paid at least once. That ratifies the agreement. Then we've got a tenancy. And we can talk about the Landlord-Tenant Act. Yes?
What if you rent a room out in your house? Is that covered by this act?
Depends. It certainly can be. If you have a measure of rent that is agreed upon between the two parties, and I like to see contracts, but if you've got that reduced to writing or if you've got that reduced to a pattern of conduct, then yes. The thing that differs is not really the structure, it's the relationship between the parties. You need to have a relationship where one person is requiring a certain amount of, I've seen tenancies created where it's an exchange of services rather than money. I don't like those, but I have seen them. And that would not necessarily be outside the protection of the Act. So yes, you can rent out a room and still be covered by the Act. So, what we're going to talk about first is that there are a number of prohibited terms that you cannot have in a residential lease agreement. Again, we've made a decision as a society that in some ways a residential tenant has less bargaining power than a residential landlord. And so we've decided that we have to put some limitations on the negotiations between the parties. Because left to their own devices, tenants would, for a lower rent level, probably negotiate away their shirts. So, there's a limitation on what you can have in a residential lease agreement. You cannot have a provision in a residential lease agreement that waives the protections of state law. If I could do that, I would have the shortest lease in town. It would be names, rent that's due, you waive all protections of the State Landlord-Tenant Act. Then I wouldn't have to evict them. I wouldn't have to maintain the premises. I wouldn't have to do anything because they've waived their protections under the Landlord-Tenant Act. Obviously, we can't have that because if I came up with that, you can imagine that all the other lawyers in town would come up with that, and we might as well not have a Landlord-Tenant Act. So, first rule of Landlord-Tenant Act, cannot waive protections of Landlord-Tenant Act. Second one, no attorney's fees provision. One of the very few legal agreements between two parties where you can't have a provision affording for a victor's attorney's fees. It's a prohibited lease term. You also cannot have an exculpatory clause. We are very familiar with exculpatory clauses in our everyday life. They are the signs at the gym that say, use this gym equipment at your own risk. It's the waiver you sign before you go whitewater rafting, saying if you die, you won't sue. A good plaintiff's attorney, and I believe we just had one, will tell you that an exculpatory clause is worthless. Where there is negligence, there is liability. So you're wasting your time with an exculpatory clause to begin with. In a lease, an exculpatory clause commonly reads, you are renting this property as is. Or Landlord assumes no responsibility for anything bad that might happen to you in this property. Almost every lease I see has an exculpatory clause. When I do lease reviews in my office, the first thing I do is look for the exculpatory clause and mark it out, because it's a prohibited lease term. Having a prohibited lease term in your lease and attempting to enforce it exposes you to a 2 months rent penalty for attempting to enforce it. So, used to be a 2 months rent penalty just for having it, but the 2011 amendments realized that landlords shouldn't be punished for out of compliance leases unless they try to enforce it. So, those are your prohibited lease terms. Cannot have those. Now we're going to get to what tenants are obligated to do. Now keep in mind when I talk about landlord obligations and tenant obligations that these are the bare minimums that are set by state law. If your lease gives a tenant more protections than state law, you are governed by what your lease says. The most common thing I see is a certified mailing requirement. I'll see a lease that says all notices must be served by certified mail. Absolutely nothing in state law that requires notices to be served by certified mail. But if your lease says notices must be served by certified mail, well then notices must be served by certified mail. You can give them more rights by contract, but you cannot take their rights away by contract. So tenant obligations, the landlord and tenant obligations under the Act, will act as a gap filler. If your lease is silent, the Act is going to step in and fill in the gaps. Or if your lease gives them fewer protections than what are here, then this will trump. So it is important to read your leases in addition to knowing what the Landlord-Tenant Act says. Now your tenant obligations. Your tenant must maintain the dwelling unit. This is generally known as the don't cause waste provision. Your tenant is not allowed to punch holes in the wall. They have to use the dwelling unit as a dwelling unit. They have to dispose of waste, keep the plumbing fixtures clear, not disturb the quiet enjoyment of the neighbors. Quiet enjoyment being a legal phrase that just means they can't have wild parties. That's sort of just what we expect from a tenant. They also must comply with any rules and regulations that the apartment community or single-family landlord has promulgated. Rules and regulations can be as expansive as no glass by the pool to as little as don't park on the grass. If you have rules and regulations and you give them to your tenant, you can require that the tenant abide by the rules and regulations. Keep in mind, though, that when you start micromanaging your tenants' lives, you expose yourself to other problems. The one I see most commonly is quiet hours at apartment communities. That's opening yourself up to a fair housing violation. That and only allowing adults by the pool, or all people under 16 must be accompanied. When you start getting very narrow in what your rules are, you open yourself up to challenges. So, tenant must also not unreasonably deny the landlord access. Access rights are interesting. With a 48-hour written notice, a residential landlord can make entry into a tenant's property to inspect, to repair, to do whatever they want. And a tenant is not allowed to unreasonably deny a landlord's access. However, the Act does restrict a landlord. They can't use their rights of access to abuse or harass the tenant. I have situations where landlords will put up 48 hours notices every 48 hours for consecutive weeks, usually when a tenant is behind on their rent. Just because they think they can, and they figure if they show up that much, it'll annoy the tenant into paying. That would be a violation of the Act. At the same time, if you do a 48-hour written notice to make entry, that does not necessarily mean that the tenant's going to lock up the dog. You could end up getting bitten. And if the tenant refuses you access, your 48-hour notice of access is not going to trump a tenant's refusal. If you call the cops are not going to take your side. Them denying you access is a violation of a lease. I can evict for that, but there's no self-help remedies in landlord-tenant law. It's the second thing I would have tattooed on my forehead. So if your tenant denies you access, your 48-hour notice, the cops aren't going to force the tenant to let you in. I can evict for it, but the cops are not going to take your side in that battle. I have a lot of landlords that learn that one the hard way. The tenant must occupy the leased premises only as a dwelling unit. This happens with your in-home daycares, with your in-home catering businesses. I have an in-home tailoring business that I'm trying to shut down right now. Unless otherwise provided by the lease agreement, tenants are only allowed to live there. They're not allowed to do business out of it. This is not me being unreasonable. This is the increased liability risks to the premises if daycares are going on in residential property. Landlords have to worry about their insurance policies. Their insurance policies are not going to cover in-home daycares. So,
Question on that, is it okay for a landlord to require a tenant to provide renter's insurance?
yes. The question was, can a landlord require tenants to provide proof of having renter's insurance? Absolutely. And that's the best thing a landlord can do. Tenants will on occasion burn down rental property. You like to have a pot of money for that. Sometimes, for no fault of their own, pipes will freeze, things will flood, tenants' property will be ruined. If tenants have renter's insurance, it makes them less inclined to want to come after your insurance. So yes, renter's insurance, best thing that ever happened to a residential landlord. Tenants must pay rent according to the terms of the agreement. Self-explanatory, but responsible for about 80% of my livelihood. Tenants failing to pay rent in accordance to the terms of the agreement. There is no legal ability for a tenant to withhold rent in the state of Alabama for repair issues. The tenant's obligation to pay rent and the landlord's obligation to repair are what we call concurrent, not contingent obligations. They don't depend on one another. A tenant has an obligation to pay rent even if the landlord is not repairing. A landlord has an obligation to repair even if the tenant is not paying rent. That would be another thing I would tattoo on my forehead. Tenants, when I find myself in court, they often say, oh, well, I would pay the rent if the toilet didn't leak. I would pay the rent if the ceiling was not caving in. And that's not a defense. That is not a legal defense to an eviction action in the state of Alabama. Some states that have enacted different parts of the Model Act will allow a tenant to abate the rent until the repair is made. It will allow the tenant to make the repair and bill the landlord, or it will allow the tenant to pay the rent into court until the repair is made. Alabama has no such mechanism. Yes?
How much notice do you give them before you lock them out?
The answer is that we never get to lock them out, but we'll talk about how we evict them in a bit. No self-help remedies. That's if you walk away from here with nothing. We'll talk more about what self-help remedies are and why we don't do them. And if we turn the cameras off, I have so many stories. I have so many stories, but my clients, their ears are burning all over the state. All right. Now, abandonment. If your lease requires it, this is a 2009 amendment. If any of you have been residential landlords, you'll realize that at some point you have a tenant, you have a property, rent's not coming in, utilities are off, you make entry, and you've got a bunch of stuff. And you don't know if you have a tenant, but you certainly got some stuff, and you don't know what to do. I have no doubt in my mind that the Alabama State Legislature wants it to be such that after 14 days of this situation, you can enter, dispose, and relet the property. No doubt in my mind that's what the Alabama Legislature wants to do. They have not yet managed to do it. They try every time, and they're trying again this legislative session, but they're just never going to be able to do it, because when a tenant, what a lease gives them is the right to live there. And that lease is only going to end if a judge says the lease is over, or if a tenant has surrendered and abandoned that contract. The best abandonment in the whole wide world is when a tenant hands you their keys and says, I'm out of here. Because now we know the tenant is not going to be coming back. Nobody can say with a straight face, I turned in keys, but I'm coming back later. Abandonment, whether a tenant has abandoned a leasehold, is a legal question that turns on a variety of factors, but the ultimate question is, does the tenant intend to return? The subjective intent of the tenant. Now, very few landlords are mind readers. Very few tenants know what their cameras, sorry, not going to go there. Very few landlords are mind readers. And so all we can do is look at the multi-factors that might indicate what a tenant is thinking. You know, have they paid rent? Are the utilities on? Are they living there? Abandonment is one of these things where no matter what the legislature does, it's always going to depend on a tenant's subjective intent if the tenant intends to come back. So, technically, as it stands by statute right now, if your lease requires it, a tenant who has gone for more than 14 consecutive days without telling you has presumptively abandoned the leasehold. Trying to prove that a tenant has been gone for 14 consecutive days is actually quite difficult. Unless you're in an apartment community, you live on site, and you spend 14 consecutive 24-hour periods watching the door. So when I tell people, if you get into a tenant's property, they are not responding to your calls, they have not paid the rent, the utilities are turned off. If there is anything bigger than a toothbrush in that tenancy, you need to call a lawyer. Because this is actually a trick. Every once in a while, you'll have a tenant that will leave just enough behind that they'll wait and see what you do, and then they'll turn around and sue you for it. I'm in small claims at least once every 2 or 3 months on this exact issue. Abandonment turns on a tenant's subjective intent. Unless you're a mind reader, it's very difficult to prove what someone else is thinking. Didn't say I lost, I just said I end up in court a lot. Now, security deposits. We're on to landlord obligations. Yes. Mm-hmm.
If you have the, I suppose you can't even release the property until you finally get that all settled.
Mm-hmm.
But I mean, if you moved all their stuff into the garage and started work on cleaning it up, how?
When we start touching tenants' belongings, we expose ourselves to some liability of what happens if we drop the tenant's belongings. I have tenants that all of a sudden discover great-grandma's diamond ring in chest of drawers, and trying to prove that it isn't there is actually pretty difficult. So when you find yourself in the situation of an abandonment, recognize that any step that you take presents some risks, and call a lawyer. Because I have some people that have done this 5 or 6 times. Some tenants that have done this 5 or 6 times to landlords. They're quite good at what they do. So just keep that in mind, that while I have no doubt in my mind that that is what the statute intends. I've actually talked to a couple of the legislators that were involved in passing the 2011 amendments. It's fundamentally impossible, unless you have a landlord that lives on site, to demonstrate 14 days of consecutive 24-hour period absence. You have tenants that are living at their boyfriend's, using your property as a closet. You have tenants that are waiting for that truck so that they can get that last piece of property out. Abandonment means that the tenant has surrendered and has no subjective intent to return. Yes?
So they do surrender in writing?
With keys.
Well, not the keys.
I would love the keys.
But in writing from a CEO of an LLC, and they leave all of the personal property, possessions, contents in the lease space.
Mm-hmm.
After they've abandoned it. Say it's yours as the landlord. How long do you have to wait
Okay.
without that being a writ, or not a writ, but or get a writ of attachment, or
See, the questions. I teach a lot, and I have a story about teaching with questions, that I really do encourage questions, and but some questions are more complicated and require a deeper discussion. Now, her question is a sort of a see me after class kind of question, because we don't want to have the whole room talking about, The greatest story is when I was in law school, I dated a guy who was in medical school, and we went to a dinner party. And in the middle of the dinner party, some girl came up to him, moved her blouse aside, and showed him this mole and said, "What is this?" And he looked at it, and because he was a bit of a pain in the backside, he said, "That's cancer." And so every once in a while I get questions, and I tell people that they're moles at the dinner party because they require more in-depth examination. Not that they're bad, not that they're necessarily cancer, but we just don't want everybody else seeing our mole. So that's my question story, but I'll talk to you after class. So landlord obligations. Landlords have a restriction with regards to security deposits. You can only demand or receive 1 month's periodic rent as a security deposit. 1 month's periodic rent, that is it. So if you have rent of $500 a month, you can get a $500 a month security deposit, or a $500 security deposit in advance of the rent. Security deposits are wonderful and interesting. They came about, again, when I talked about landlord tenant law, I said that it was as old as 1066, William the Conqueror. Security deposits are relatively infants with regards to the rest of property law. They developed in the 1970s in a reaction to waterbeds. All of a sudden, all the tenants in the world wanted to sleep on a bed of water. No idea why, but at some point in time, those beds of water would break, and then you'd have a huge mess. And so landlords needed a pot of money to hold back from when that tenant busted that bed of water. And that is why we have security deposits. Security deposits are not designed to ensure that the property is given back to you in the same condition that it was let out. It is designed to ensure that the property is given back to you in roughly the same condition it was let out, excepting reasonable wear and tear. The law assumes that a residential tenant is going to cause destruction to your property. The idea is that they cannot cause destruction to your property that is unreasonable. Reasonable wear and tear is one of these wonderful things that most landlords don't understand and hate to have me talk about. And I'm going to use my favorite example, which is the blinds, the mini blinds. If we use mini blinds and we take the blinds up and down and up and down and up and down and up and down every day for a year, at some point one's going to break. Even if we're using them like normal people use mini blinds. So when you go into your tenancy and you find a couple of mini blinds that have broken, there's an incentive to take the security deposit and think, ooh, free mini blinds. No. If the tenant's use of the property was reasonable, that wear is a cost of doing business. Not reasonable would be doors that are missing, light fixtures that are missing, copper that is missing. Not kidding. Carpet with holes, carpet where they've never let their dog out. That is not reasonable use. That is not wear that comes about with reasonable people using the property, because reasonable people let their dogs out. Reasonable people don't steal things. That's what a security deposit is for. So, you can demand or receive 1 month's periodic rent in a security deposit, except in the case of increased liability risk to the landlord or premises. That does not mean poor credit score. Poor credit score is not an increased liability risk to the landlord or the premises. Increased liability risk to the premises would be if they wanted to paint it black. It's going to cost more money to paint it back. If they wanted to put up some sort of ramp, that would be like having an additional security deposit to ensure that the ramp is removed in a workmanlike conduct, that would be fine. But generally 1 month's rent as security deposit. Never charge less than 1 month's rent as a security deposit, because you're going to want that money. If the tenancy goes well, you're giving it back, and that's wonderful. If the tenancy does not go well, at least you have 1 month's rent in the bag that you can hold. So that is the restriction on security deposits. You can charge a separate pet fee. My personal preference is to never charge a pet deposit. Deposit implies they're getting it back. They're not getting back a pet fee. I've never met a pet that hasn't done at least $250 worth of damage in a years-long tenancy. That includes bunny rabbits, maybe fish, maybe. Maybe a fish wouldn't do $250 worth of damage to a premises in a year, but a dog certainly is going to. So a pet fee is for the privilege of having a pet. You do not have to let them have a pet in the tenancy unless you want to, or unless that pet is a service animal. If that pet is a service animal, we can't charge a fee on it anyway. But 1 month's rent security deposit and non-refundable pet fee per pet. Always a good way to go about it. Landlords also must disclose who is authorized to manage the premises and an address for where service of process can be had. That means you have to say where your address is if you want to get, well, you can't serve a P.O. box, but if you want to get a registered agent, you can disclose that instead of your own personal address. But the idea behind that is legal services needs to know where to send the lawsuit if they have to sue you. So required disclosure in your lease agreement is the address at which you can be sued. Or if a property manager, the address in which the owner can be sued. The landlord must deliver possession of the dwelling unit. That is, again, an obligation under the Act. You have to be able to deliver possession of the dwelling unit. This is a big problem in apartment communities where they try and stack leases as tightly as possible. They'll have 1 3-bedroom apartment, and it's supposed to be vacant on the 1st of June, so they'll start the lease on the 2nd of June and then be very surprised when the first tenant doesn't move out, and then they're holding the bag when the other tenant wants to move in. You have an obligation to deliver possession of a dwelling unit. Don't rent something you don't have exclusive possession of. Landlords must act with good faith. Good faith is actually a bilateral obligation. Tenants must act with good faith as well. Good faith, I was kind of hoping that Mr. Glover would define it. He did willfulness. I was hoping he'd do good faith. Good faith is a legal term. Basically means we're going to be honest and upward and upstanding in our dealings. Good faith is the provision of the Landlord Tenant Act where a judge will deny your eviction even though you've done everything legally correct. I have lost a few evictions in my 7 years on good faith. This is landlords that are doing things that I really wish they would not have done, or they would have told me they had done before we found out about it in court. Generally, we do not lie, drunkenly call, or otherwise stalk our tenants. If we do, that is a violation of good faith. Landlord-tenant relationships can get very nasty very quickly. You need to always, I tell my landlords to take a step back, recognize that none of this is personal, and that there is a grander force in the universe, because losing an eviction on good faith is embarrassing to the landlord. And I have all sorts of stories, but I cannot tell them while a camera is on. So, landlords must act in good faith, generally be nice. That's the golden rule. Treat them like you'd like to be treated. There but for fortune go I. Landlords must maintain the premises. Generally means that all of the fixtures are going to work, that you are going to have plumbing that works, that it is going to be up to the standards of the code that was in place when it was constructed. You're going to have lights that turn on, you're going to have a roof that doesn't leak. Alabama landlord-tenant law has what we call an express warranty of habitability, which means when a residential landlord rents something out, they are saying that this is fit for human habitation. Now, I have some tenants that think that the landlord has violated their duty to maintain just because the toilet runs a little. I got some tenants with some unrealistic expectations. But I've got some landlords that think it's fit for human habitation if you've got holes that you can fall through the floor into the crawl space. So I've got some landlords with some unrealistic expectations too. Generally, when it comes to maintaining and your warranty of habitability, you need to understand that it's supposed to be fit for human habitation. And if this ever gets before a judge, you're going to be the one trying to argue that you have kept it to the standards of human habitation. And judges don't like hearing that people don't have heat in the winter, that they don't have air in the summer, even if they're 7 months behind on their rent. Because remember, a landlord's obligation to maintain and a tenant's obligation to pay rent are not dependent upon one another. They run concurrent, again, not contingent. So, even if your tenant hasn't paid you rent in 7 months, we've got a remedy for that. The remedy is not refusing to fix something. And ultimately, they'll live there without air conditioning anyway. I've seen it. And they do a lot more damage to your property without air conditioning. So, that is the landlord's duty to maintain. We're going to talk a little bit about attempts to revise the Landlord Tenant Act. I got about 10 more minutes, I think, somewhere in there, and then we'll talk about questions. I'm not really sure when this ends, so I'm just going to talk.
10 minutes.
10 minutes, all right. The Landlord Tenant Act, as I said, has been revised twice. There is a current attempt right now to revise it. It is Senate Bill 291. It was introduced by Senator Marsh on the 28th of January of this year. It is in Bill Read Committee, first read, or no, it's been referred to committee, it's on its first read, and I hope, I can't really say this because I'm being filmed again, I'll talk to you a little bit about it when the cameras go off. But it's, again, they're attempting to tweak it because they feel that it is unfair, or who knows why they're attempting to tweak it, I've got no clue. So, as I said, we've got landlord's obligations, tenant obligations, we have defaults. What happens with defaults? If a landlord doesn't repair, that's the most common landlord default. A tenant can give them a 14-day written notice saying you must repair X or the lease terminates. If the landlord doesn't make the repair, the tenant can move and sue the landlord. I have in 8 years never seen a tenant do this properly. They usually give the notice and then don't move, or they don't give the written notice, or they skip 5 days into the 14-day window, but that is out there. So if you have, in one case, it has to be a health and safety related repair issue. Most common, one I had a couple of months ago that I thought was interesting was a garage door that was stuck on open. If you brought it down, it wouldn't open, it was locked, but then if you brought it up, it wouldn't go down. And so the tenant either could be locked into their house or everyone could get into their house. That was health and safety related. And it took 18 days for the landlord to make the repair, not because the landlord was not trying, but because the part was on back order. Thankfully, the tenant in that case did not give a written notice, so we were saved by that. But had the tenant given a written notice, the tenant would have been entitled to break the lease and sue the landlord for any damages that they suffered as a result of breaking the lease. You know, the moving van, etc. So that's what happens if a landlord does not meet their obligations. That's the default mechanism for that. There are, of course, others. The tenant mechanisms, if the tenant defaults, is the eviction. That is the eviction. Self-help is never allowed. There is no mechanism by which you can safely do something without a court's say-so. You cannot turn off the power. Even if the tenant has the power put into your name and you're not legally obligated to provide power for them, if you padlock that meter or cut off that power, you're exposing yourself to a significant portion of significant liability. Legal Services recently had a case where a landlord shut off the power and the tenant had a grandson who was visiting that was on oxygen. The oxygen machine required power. That did not play well in front of the jury because they had the grandson walk in with the oxygen machine and the landlord was the one that shut off the power, and I was just so happy I wasn't sitting next to the landlord in that one. Can't do that unless your shirt says Huntsville Utilities, don't turn off the power. I mean, and every year around Thanksgiving and Christmas, I got people who shut off power, and I'm on the phone trying to get them to turn power back on. If they're stealing your power, we can evict them for that. But you can't do a self-help remedy. Self-help remedies are disfavored by Alabama law because, again, the whole point of the law is to keep us from all shooting each other. And if you've got people that are just changing locks and putting stuff out, we're going to have a lot of people getting shot. So anything without a judge's say-so or without a sheriff standing there is going to be generally disfavored and expose you to liability under Alabama law. And I have 5 minutes. So the question, and retaliatory conduct, evicting them because they call the city on you, also prohibited by statute. So here the question is going to be is, can I do an eviction in 5 minutes or less? Because I think that's what everybody wants. And I'll stick around after this class. And again, thank you for having me. I don't think I swayed as much this time as I did last time I was here. Evictions in 5 minutes or less for non-payment of rent. Here we go. A tenant that is behind on their rent is entitled to a 7 calendar day notice. That notice has to specify the amount of rent they have to pay in order to avoid eviction, has to specify that they have the right to pay it to avoid eviction. That notice needs to be nailed and mailed, posted on the property, sent regular U.S. mail. And should the tenant fail to cure and pay the full amount of rent that is owed in that 7-day window, an eviction can be filed. The only way you're going to lose a non-payment of rent eviction in the state of Alabama is if you do your notice wrong. It means if your notice doesn't have what the statute requires, if the notice is not served according to statute, or you jump the gun and don't wait until the notice expires. If the tenant comes to you with the full amount of rent that is due, you have to take it. You cannot say no. You all look at me like, why would you do that? And I say that's because you're trying to evict the tenant for something else, not rent. Rent is the easiest way to evict somebody, so sometimes we give that notice, cross our fingers, and hope the tenant won't pay. If the tenant does pay, they avoid eviction until the next month rent comes due. Then you can do it all over again. 7-day notice when rent is late, see if they pay. If they do not pay in the 7 calendar day window provided for by that notice, you can file. If you have an LLC or a DBA or otherwise a business, you have to have an attorney to file an eviction. And you cannot file an eviction on behalf of someone else. Only lawyers can file legal actions on behalf of corporations or other individuals. So if you have an LLC or you're doing a DBA, which is what you should be doing if you own rental property, you have to have a lawyer. Lawyers are not that expensive. It is not worth it to avoid the protections of an LLC just to avoid having a lawyer with your evictions. I have clients that make that argument with me all the time. It's not worth it. Have a DBA or have an LLC. Just have an LLC. So from the day that the eviction is filed, tenant has 7 calendar days within which to request a court appearance. If they do request a court appearance, that is calendared within 14 days. If they do not request a court appearance at the expiration of that 7-day window, I can file a default, which says I'm entitled to win because the tenant has failed to answer and I get to win by default. From the day the default is granted, 7 calendar days until the writ can be filed, which gets the sheriff out there. Average eviction in my office is 21 days, start to finish. If the tenant does request a court appearance, that usually serves to buy them an extra week, depending on their judge. At court, all I have to do is demonstrate a notice was given, no payments were accepted after the notice was given. I'm entitled to an immediate order of possession that is stayed for 7 calendar days. That is an eviction. It can be, we do, again, 150, 200 of these a month all over the state. I would say about a third of them request court appearances. About 10% of them go to writ, writ being when the sheriff shows up. Sheriff will not provide you labor. Sheriff will just show up to make sure, again, nobody gets shot. The hiccups on the eviction, you're going to lose your eviction before you file it because your notice is going to be wrong. I've actually never seen a pro se landlord first time out do a notice correctly because there's a lot, it's hyper technical. There, I mean, we have a 7-day notice that we provide for our clients. It has 4 pages of instructions, and we still bounce quite a few evictions before they even get filed on bad notices. With 4 pages of instructions, it's got 7 blanks, but it's hyper technical, and it's all sort of complying with the statute. But that is an eviction for non-payment of rent. You can also evict a tenant. 14-day no curable notice if they lie to you on their rental application. Make sure they fill out their rental application. If they leave blanks, that's not lying, that's just not filling out the form. Also, you can do a 7-day non-curable notice for discharge of a firearm, not in self-defense, criminal assault, not in self-defense, and drug activity. So those are the other ways to get rid of a tenant. All right, questions. I can take one very quick question. Yes, sir.
On the notice of termination,
Mm-hmm.
do I have to have a person witness that, or can I just put it up on the door if I say?
Okay, the question was on a notice of termination, do you have to have a witness you do it? I have seen, notices of termination are hysterical. I have seen a client, he took the newspaper for the day, a photo of the door, and a picture of himself posting it on the door with the day's newspaper. It was awesome. You do not. The way that you demonstrate to a court satisfaction that you posted something is by your testimony that you posted something. So if you generally are truthful, you would just testify that you posted it. It's also a nail and mail mechanism. So yes, you're nailing it to the door, but you're also relying on your friendly neighborhood mailman to get it there. So they don't have to be notarized. They don't have to be witnessed. The way you're going to demonstrate that you posted it is to, in fact, testify that you posted it. Okay, well that was, got off to a very slow start. I'm sorry again, not used to standing still, not used to not having a PowerPoint, not used to the podium, but thank you for having me.